My name is Tim Shea, and I'm the owner of Shea & Associates. I want to talk about medical malpractice because that represents a significant portion of my practice and the practice of the firm. The first thing that we ask a person who is going to meet with us that believes there is a potential medical negligence case is to get a complete copy of their medical records, as many of them as they can get. And ever since the Affordable Care Act has been enacted, the hospitals, the medical providers, all have electronic records. And these can be downloaded very easily on a disk or even your email. So it's not as difficult to get medical records as it was in the past when you're getting a paper file. But the most important thing that you can do when you come and meet with me is to have a copy of your medical records and have a timeline prepared so that when we discuss what has happened in the past that led up to what you believe was an act of medical negligence, that I can have a good history to start with. The statute of limitations for medical malpractice cases are a little gray. We start off with 2 years from the act of medical negligence. Sometimes we have a situation where a person may not know there was medical negligence in a failure to diagnose case because there will not be a diagnostic study until later on. In that period of time, it is 2 years from the date of which you should have known that there was act of medical negligence. We also represent parents who have children who have been the subject of medical negligence. We have a few of those actively going on now. And the statute of limitations is told during their minority. So it's not as important to have that filed immediately with a child, but it is important to speak with an attorney to get an idea whether there has been medical negligence. Shea & Associates is your civil trial law firm. If you've been involved in an accident or suffered injury due to somebody else's negligence, please contact us for a free consultation